When I explain to people that one of the most important reasons to do estate planning is because you could become incapacitated by an illness or an injury, I often hear one common mistaken assumption about estate planning. People will say, I'm married. My spouse can make decisions for me if I become incapacitated. That simply is not true. My name is Patrick Cawley. I am an estate planning and elder law attorney with Keystone Elder Law in Mechanicsburg, Pennsylvania. I want to tell you about a tragic case I'm looking at right now that is really not all that uncommon. A husband and wife suddenly experienced a drastic downturn in the wife's health. She is unable to speak to the husband, to the doctors, to anyone. The wife ended up in the hospital and is going to need long-term care in a skilled nursing facility once the hospital stabilizes her. Here's the trouble. The way they had their finances set up, there's a substantial amount of money in the wife's account, but only the wife is on that account. The husband is not named on the account and has no access to it. They did no estate planning, so there's no power of attorney to allow the husband to access that money to then pay the skilled nursing facility where the wife is headed. So how they're going to pay for care in the very near future is an open question, and it's a stressful question for them right now. So that's the first problem. The second problem is, what about signing the agreement to even get into the skilled nursing facility? Unless the husband is legally standing in the shoes of the wife to sign that agreement and to agree to pay and agree to all the conditions of the facility, they may or may not be able to get the wife admitted to that facility. Again, a power of attorney would have allowed the husband to sign that agreement standing in the shoes legally of the wife. The next question is, how are they going to pay for the long-term care? Long-term care is very expensive. Now, Medicaid's available to pay for long-term care, but Medicaid has strict financial guidelines. If the wife currently has the lion's share of the couple's money in an account that only has her name on it, well, they have to shift that money around to get it out of her name so that she becomes financially eligible for Medicaid to pay for her long-term care. That brings us right back to the first issue. How are they going to do that if the husband has no access to that money? Simply being the spouse does not give the husband access to that money. A power of attorney would have, but they didn't do any estate planning. And so the list of concerns goes on and on. Most likely where a case like this is headed is you have to go to court and you have to have a guardianship proceeding. You have to put a doctor on the witness stand to talk about the medical treatment. You have to go through all of this extensive legal wrangling to get the decision-making authority that could have so easily been set up in a careful estate plan involving a power of attorney. So just because you're someone's spouse does not mean you have legal access to property that's only in that spouse's name. The results of relying on that mistaken notion can be tragic. Please reach out if you have questions about this. Send me an email at info@keystoneelderlaw.com or give us a call at 717-697-3223. Happy to talk to you about where things might be headed if you had a sudden decline in your health or your spouse's health, and what legal preparations you need to make now to be ready for that.